Hello, this is Phyllis Roman with Giamanco Law Partners, here with another how-to video to explain some of the legal processes to you. Today, the question that I'm going to go through is some tips for testimony, whether you are testifying at trial, at a deposition, at an arbitration, whatever it happens to be. These are some tips that can help your testimony be more effective and therefore help you get better results. Now, before we get into these tips, I am not advocating to lie or to perjure yourself. The number one, not even a tip, the number one rule in testifying is to tell the truth. Oh, if you do not, you can open yourself up to perjury. In fact, it generally just gets more confusing. You're not going to remember what you had said unless it was the truth. You're trying to keep your lies straight. Just tell the truth. The tips that are going to follow in this video are simply to make your testimony more effective, to take what happened and how you're talking about what happened and make it the most effective to get you the best result. Not to tell you how to lie or how to put forward the best story in testimony. So now that we have that disclaimer out of the way, some tips that are going to help you in your testimony are coming up. The first one, answer the question that is asked. I understand, your attorney understands, the judge understands, everyone understands that you want to get out what happened to you. You are so eager to get everything out and to just do a whole narration about what happened. Just spill it all out at one time. That comes off, unfortunately, as having this prepared script and that you're just trying to remember your script. So rather than coming off as truthful and eager to let justice be done, it comes off as I'm trying to trick you and I want to get my story out, my script out before I forget it. Not helpful. You have to trust your attorney. Your attorney is going to get out everything that is necessary for your case. But it's also the other attorney's job to try and get out more information that will not be helpful to your case, because no case is perfect. There's always a few negative facts. And if you just start spouting off everything that happened, you can end up hurting your case. For example, if you just start spouting off what happened at a car crash, I was at the stoplight, he came out of nowhere, it hit me from the back end, but then, I ended up getting arrested because I didn't have a license. Whoa. Now you can't take that back. And it's more likely than not that whether or not you had a license was not relevant and would not have come in. But now the jury or the judge has heard that you were arrested. And regardless of the rest of the facts, that you were stopped at a stoplight and get rear-ended, it's going to hurt your case because all they have heard now is that you got arrested. Regardless of the fact that the crash wasn't your fault, regardless of the fact that it has nothing to do with whether or not you were injured in a car crash, it doesn't matter. So you have to make sure you answer just the question asked. One example that I often help to tell clients when I'm preparing things is, the question I ask is it raining today? And I can look out my window and tell you, no. The end. That is the answer. It is not, no, it had been raining a lot. Actually, Illinois had a ton of rain the end of April and May, and there was lots of puddles, people were flooding, and it finally was drying. Stop. The question was, is it raining today? It's a yes or no answer. Not every question is yes or no. They often require more than that. But listen very carefully to the question that was asked and keep your answer just to that question. Did you see the car prior to impact? Oh, there was no time to see him before. All of a sudden he just hit me. Stop. Did you see him prior to impact? Yes or no? You're getting into all sorts of other things. Keep it tight and listen to the question that is asked. Tip number 1. Tip number 2, how you speak. Speak out loud, speak clearly, slow down. The last part of it is most helpful for me. I tend to speak extremely quickly, and The problem with speaking quickly is that before you even are moving on to your next statement, someone who was listening, a jury, a judge, the other attorney, is still trying to process what you've already said. And that makes it hard for them to listen, and it makes it hard for them to understand what you are saying. So slow down. Speak clearly. Don't mumble. Don't speak quietly. You have to be able to project your voice. Don't talk with your hand in front of your mouth. Things like that. Speak in a clear, loud voice so everyone can know what you are saying. Speak out loud. Now that seems bizarre. Why is it even possible to not speak out loud? What I mean by this in this second tip is nuh-uh, none of those are going to be clear or understandable, frankly. And not only are they not very clear, it gives the other side an opportunity to try to twist your words. Saying yes or no or of course, you can't twist that. It's yes and no. But if you say sounds like a yes to me, but maybe they can say, well, that what they really meant was a no. They said Very unclear. Not only that, if you're at a deposition and it's being transcribed by a court reporter, that doesn't read back. It reads back as MHHMM. Does that mean anything? No. So similar to how you would in an email or a text or anything that is where you're typing it out, keep your answers verbal and out loud. That way any transcript is going to read back correctly and no one else can twist your words. It is clear and concise and people do not misunderstand what you're saying. Similarly with gestures. So if I'm saying, I think it was about that far apart. Okay, I can see that right now in this video. But a lot of times in testimony, there is no video. And it's taken when they're just going to be reading a transcript out loud to a judge. Or a judge is going to be reading it later. Saying about this much means nothing in a transcript. You need to speak out loud and say, it was about the width of a ruler. Or the length of a ruler. That is the kind of thing you need to make sure you are utilizing. Always out loud, clear, not muddled, not mumbly, not quiet, and also slow down, which I will take to heart as well. So tip number 2 has to do with how you are speaking. Tip number 3, use your own words. A lot of times people want to talk like an attorney because they think it's what people want to hear. It's not. And it comes off as fake. It comes off as the fact that maybe your attorney taught you a script and now you're trying to remember it. It just comes off awkward and stilted. The most effective testimony is going to be in your own words, is because that's how you talk. If you're talking like someone else, it's going to come off as insincere. Whether that's not truthful or not is one thing, but it's going to come off as insincere to a judge or a jury or another attorney, whoever's listening. A lot of times that means, frankly, ignoring partially what the attorney has asked you. So if someone from Europe was asked, well, how many feet away were you? They could maybe ask, the answer, I'm not sure, I don't know feet, but I was around 2 meters away from the car. Completely fine. And it comes off as credible and honest and not an error. Because if you're not used to using feet or you don't measure things in feet, it's highly likely you're going to get it wrong. So even if a judge says, well, how far away were you in feet? You don't have to answer in feet. I, for one, am not great at measuring things. I find car lengths the most useful measurement when I'm talking about a car accident. So while not uniform, so it's not great as far as attorneys go, because we like uniform measurements, everyone knows that, I was 2 car lengths away from the light. All right, maybe it's 15 to 25 feet, but people get a feel, people conceptually understand what 2 car lengths is. And it comes off And you're more accurate because it's something that you measure in and you understand. If you're trying to do a measurement that you don't know, it's going to be problematic and it's going to be false, frankly. Not on purpose necessarily, but will often be false. So just make sure you're utilizing your own words, even if the attorney who's questioning you is asking in phrases that you don't use. You can change it up. You don't have to use their terminology. Tip number 4, do not exaggerate and do not guess. These are constantly cause problems. They come off as disingenuous. They are a gift or a windfall for the other attorney. It's just not helpful. I understand why people want to exaggerate because you want to make sure people are fully understanding. I slipped and fell at a location and my back was in so much pain. It was a 12 out of 10 pain. No, it wasn't. It just wasn't. If 10 is the most excruciating pain that you can ever imagine, your pain wasn't a 12 out of 10. And all that does is it makes it seem like you're money grubbing and you're trying to get more sympathy and therefore more money as a result of this. I've had people say that their minor whiplash that they had was worse than childbirth. Every woman on that jury is going to roll their eyes and say, not a chance. So exaggeration is not helpful. You can get across how painful this was. This is not to minimize your pain. Absolutely, you experienced pain. But exaggerating it or exaggerating the fact that this was the worst thing, that's the worst crash you've ever seen. Oh, yes, this crash, I can't believe I'm still alive. And then I pull out a photo of the car and it's a fender bender. Doesn't look good. Don't exaggerate. It's going to come off false. It's going to come off as insincere, and you're going to end up hurting your case rather than helping it. It goes back to what I said at the beginning. Tell the truth. The same thing goes for guessing. This is something that attorneys often trap deponents, witnesses, parties into their testimony. We love exact measurements. So I want you to be able to tell me exactly from the moment you walked into that store until the moment that you slipped and fell, how long was it? No, I want to know exactly. Was it an hour? Was it 2 hours? Was it 2 minutes? Don't let the attorney force you into guessing. I once had a client who stated that she'd come up to a stop sign, come to a stop, was waiting for traffic to clear, and there was no traffic coming in either direction. And the other attorney asked her, well, how long were you stopped for? And she said 5 minutes. There was no traffic coming from either direction, and you were stopped for 5 minutes. 5 minutes is a long time. Most of these YouTube videos that Giamanco Law Partners have posted are between 7 and 11 minutes. That's half the video to be just sitting there. Don't guess. Guesstimate, kind of give it, I think it was somewhere between 2 seconds and 15 seconds, but I'm not sure because I wasn't exactly measuring the time. Fabulous. Thank you. Honest, truthful, and you don't let the other attorney trip you up. Do not guess, please. It's only going to hurt your testimony and be a gift for the other attorney to mess with your testimony. Lastly, do not lose your temper, okay? It is the job. Your attorney is there to help you and to make your case for you. It's the other attorney's job to tear it apart. And even if that other attorney is rude, is sarcastic, is personally and purposefully goading you, don't fall into the trap. If you rightfully, even if it's completely justifiable, get angry and start snipping back and getting mad and responding like, I don't have to tell you that, it doesn't help. Even if it's justifiable because the other attorney was a jerk, it comes off as, again, faking it and, that you are defensive because you are hiding something. It is not an effective way to testify. And frankly, attorneys are trained to try and push you. I have done it. I have tried and pushed a deponent, a witness that has been kind of defensive. I pushed it a little more than I would have to see if I could get them riled up. And I did. And I ended up winning the case because it comes off as that you're hiding something and that the other attorney is trying to get that out. So do not lose your cool. Even if you want to, you can go and complain to your attorney after your testimony is over. Absolutely. Justifiably so. But during your testimony, do not lose your temper. So those are my 5 tips for the day. Answer the question that was asked. Speak out loud, clearly, and slowly. Use your own words rather than those of the attorney. Don't exaggerate or guess. And do not lose your temper. All in all, though, these were just some of the helpful tips that can make your testimony more effective. Talk to your attorney, prep with your attorney, and ask any questions you may have to your attorney, and they will be there to help you, just like we are for our clients. As always, if you have any questions, if you have questions about testifying or about a case that you have going on, please feel free to call either me or any other attorney at Giamanco Law Partners at 630-635-5555. And as always, good luck out there.